I'm Hope Fry. I'm the Executive Director of Project Lifeline. I've been an immigration attorney for 40 years. This is the third installment of a six-part series about the regulations proposed by the government, which would dramatically change the rules governing the detention, release, and treatment of children detained by immigration. The first video creates a context for understanding the impact of the rules. We look at the fast-track deportation procedure called expedited removal, which is a deportation procedure used for undocumented parents with children coming across the southern border. It does not apply to children who come by themselves, who are called unaccompanied children. This is a highly adversarial process during which the individual has few rights. The second installment examines the history of the Flores settlement, an agreement that sets the nationwide standards for the detention, release, and treatment of all children in immigration custody. I'm going to call that agreement simply Flores. Flores is important since any regulations are required to be consistent with it. Part 3 and 4 discuss two aspects of the proposed regulations which would supersede and eliminate Flores and the protections it provides children. Although each segment is freestanding, watching them in order will assist and increase your understanding of the proposed regulations. This is important if you decide to take action to let the government know what you think about the practices and policies regarding the detention of children and your view of their regulations. I'll tell you how to do that in the final segment of this series. The proposed rules must be examined in light of the broader policies of the administration and their conduct towards migrants so far. Attitude is important since regulations are subject to interpretation, and past conduct is the key to understanding how this is likely to happen. Zero tolerance is still the guiding principle of the government enforcement along the southern border. The theory behind zero tolerance is that harsh treatment will deter people from coming. Zero tolerance means the criminal prosecution for illegal entry of every migrant. Sounds clear, but the actions justified by zero tolerance have far exceeded its words. Soon after the policy was announced on April 6, children began being separated from their parents, many as the parents headed to court to be prosecuted. Separation was the rule until the courts and public outrage caused the administration to discontinue this egregious practice. Under zero tolerance, 3,000 children were separated from their parents. Flores has been the law for 21 years. During that time, it has been interpreted by the courts in lawsuits brought looking at government conduct. So we have information from which to understand what Flores means and how the government has failed to behave with respect to its requirements. There's a discussion of that in the second installment of this series. Flores requires that any regulations be consistent with it. That means that the proposed regulations must fail if they are not compatible with and conforming to the protections provided by Flores. Because it is important to this discussion, I want to say this again. The agreement the government negotiated and signed, Flores, requires that its regulations be consistent, compatible, and conforming to Flores. It is through this lens that we must analyze the proposal to see if it resembles Flores. Flores, including its attachments, is 54 pages long. The proposed regulations are 203 pages long. Big difference right there, huh? The regulations are complex and, like Flores, cover a myriad of things. In this segment, we're going to look at two aspects of release. Before beginning that, I'd like to say just a few words about the effect of detention on children. Detention is in and of itself traumatic for children. The substandard conditions of immigration detention, discussed in part 2 of this series, exacerbate that trauma. The results are serious emotional and behavioral problems, as well as anxiety, depression, and PTSD. Recurring thoughts of suicide are not uncommon. Now let's turn to the regulations. The proposal by the regulations create two groups of children subject to different treatment: those who come with family, often one parent, and those who come unaccompanied. Flores, on the other hand, applies to all children. The Ninth Circuit Court of Appeals said so in finding against the government on this issue this summer in a lawsuit they brought over the summer. Defining children and treating them differently is inconsistent with Flores. The government's rationale for creating two groups of children is, quote, to permit families to be contained together and parents not separated from their children. It is important that family detention be a visible option, not only for the numerous benefits that family unity provides, and so on. Interesting, huh? Under the proposed regs, families can be detained indefinitely. That means options for release for children with family available under Flores are eliminated. All children accompanied by parents will be held in detention until all immigration proceedings are concluded. Here's a hypothetical to demonstrate what that means. Today, Maria, age 15, Fernando, age 12, and Lily, age 2, are apprehended with their mother, Luz. They are transferred from CBP custody to a family residential center. Maria's paternal uncle sponsors her release. Fernando is sponsored by his older sister. Luz and Lily remain in custody. Luz is found to have credible fear. She and Lily are released, she with a GPS device on her ankle. Under the proposed regulations, they are apprehended together. Luz makes a claim for asylum and is found to have a credible fear. The family is placed in deportation proceedings. Today, the backlog of cases waiting to be heard is 746,000, of which 140,000 are in California and 110,000 are in Texas. Their case will be heard in 2 to 3 years. Best case, Maria is 17, Fernando is 13, and Lily 4, and they are still in detention. They lose their case. Luz appeals. Her appeal is denied 3 to 4 years later. Maria is 20, Fernando is 17, and little Lily is 8, and they are still in custody. And they wait another year to be deported. Lily is 9, 7 years of her life spent in immigration detention in the United States. Now let's look at unaccompanied children. At the time Jenny Flores was detained, a child could be released only to a parent or guardian. Today, unaccompanied children must be released from custody without unnecessary delay, which has been ordered by the courts to be not more than 20 days, to one of these people in order of preference: parent or legal guardian, adult relative, which means brother, sister, aunt, uncle, or grandparent, an individual designated by the parent or legal guardian as capable of and willing to take care of the child, a licensed program providing foster care, an adult seeking custody when in the discretion of the government it appears that there is no other likely alternative and family unification does not appear reasonably possible. Under the proposed regulations, only a parent or legal guardian can sponsor a child. We are back to the time of Jenny Flores, and there's another wrinkle that's already in place and will continue. If a relative who is eligible to sponsor a child is undocumented, comes forward, he or she will be arrested and put in deportation proceedings. If a qualified person comes forward and is legal themselves but lives in a home where others are undocumented, and this is discovered during a pre-release home study, ICE may come and also arrest those individuals and put them into deportation proceedings. This policy has a chilling effect and is already resulting in the long-term detention of children who otherwise would have been released. Bond is another way a child can be released. Today, a bond hearing is available to a child from the time of arrest. Under the proposed regulations, children detained with family cannot have a bond hearing in ICE custody. Determination is not subject to challenge. They will be detained indefinitely. Under the proposed regulations, an unaccompanied child is not eligible for a bond hearing until he or she is put in deportation proceedings. Unaccompanied children are not subject to expedited removal. Rather, they have the right to make an asylum claim directly to USCIS, not in court. The interview on the case is supposed to be held within 45 days, and this is not happening. Depending where the child lives, it can be over a year for the first interview. The child must wait for a decision. If the decision is negative, a notice to appear, which begins the deportation process, is issued. It is only at that point that the child can ask for bond, which may or may not be given. It's discretionary again. During the deportation proceeding, the child can renew his application for asylum and have a full merits hearing. That'll take over a year for his case to get scheduled to court, and who knows how long before it's heard. If he loses, he may again also appeal to the BIA, a wait of 3 to 4 years. If the child is not granted bond or sponsored, he will also remain in detention indefinitely. The proposed rules are inconsistent with Flores and makes legal that which has been found by the courts to be illegal.